Good morning, everyone. Thank you for joining our webinar this morning. My name's Jen Williams and I work for Practical Vision. Many of you will be most familiar with our Lawyer Checker risk products and possibly our today's publications. So we have today's Conveyancer, today's Wills and Probate, and our newest publication, which is today's Legal Cyber Risk. In today's webinar, I'm going to be discussing the risks associated with ID fraud and client verification and what firms can be doing to help to mitigate that risk. Lawyer Check is obviously best known for our law firm to law firm bank account check, which is used by conveyancing organisations across the country. And most recently, we've expanded our products and services to help firms deal with the multitude of challenges posed by the rise of cybercrime and criminal activity. So this has seen us become a firm-wide service partner, and I'd encourage you to consider today's presentation in the context of the firm as well as just your conveyancing team. Hopefully I'll be able to give you a good steer on some of these issues and to identify some things for you to take away. If you do have any questions, please feel free to ask them during the presentation. I'll answer them by way of follow-up after the webinar. I've also included some contact details at the end of the presentation if you have any queries that you maybe want to ask directly. Okay, so I'm going to split the webinar into two parts and consider ID fraud first and then client verification. So both play a leading role in completing your obligations under the Money Laundering Regulations. And keep in mind the overall objective of the regulations. It's really easy to get hung up on getting hold of passports and driving licenses and filing them away, but this isn't the overall objective. You're trying to prevent illegally obtained funds from being legitimised through your business. So you're required not only to file these documents, but to interpret the documentation in a way that allows you to make a decision about the legitimacy of your client and their funds, hence know your customer or know your client. As you can see from recent data provided by the Council of Licensed Conveyancers, many firms are still failing to fully codify an initial risk assessment of the individual and the transaction, which is a clear requirement under the legislation. The money laundering regulations are almost unique in that they mandate that organisations complete and document the training their staff have had. And importantly, as identified by the CLC, that senior managers and money laundering reporting officers are appropriately trained in their responsibilities, which are the adoption of AML policies and procedures, the implementation of risk assessments, the requirement to maintain adequate records of staff training, ensuring that MLRO enhanced training has been implemented, and documenting source of funds. So identity fraud takes on many different forms, but the outcome is usually always the same. The fraudster uses the stolen identity to benefit financially. It can be as simple as cloning documentation to open fraudulent bank accounts, store cars, credit cards, etc. And with this information, fraudsters can enact almost any kind of fraud with the array of documentation needed to pass basic scrutiny. As identified by action fraud, the first the victim is normally aware of the problem is often when the credit card bill lands on their doorstep. So in the course of the next few slides, I'm going to show you some case studies where we'll see how stolen identities have been used by fraudsters to pocket hundreds of thousands of pounds from unsuspecting law firms. So the first case study hit the national news in 2015 when the Luptons were defrauded of £62,000 when emails between themselves and their solicitor were intercepted. The fraudster had been monitoring communications for some time and at the right opportune moment took over the email account and began his own communications with the law firm, redirecting the funds. And as much as people may decide to change their bank details during the course of a transaction, the change should have raised a red flag with the firm to enact a process of verifying the details, whether this be a manual check or an electronic check. Case study 2 is a well-known case that reached the Court of Appeal. In P&P Property Limited versus Owen, White and Caitlin, a fraudster posed as the owner of the property, convincing an estate agent to list the property, agreeing a sale, and fraudulently pocketing the sales funds to the tune of nearly £1 million. In a similar case, Dreamvar versus Mishkonda Raya, the fraudster had obtained the driving license and TV license of the property owner and used them to complete customer due diligence and fraudulently sell the property. And despite the fraud being spotted by the land registry, the funds had already been transferred to the fraudster, who pocketed over £1 million. The first instance decision in the High Court caused shockwaves, and despite its clear failings in respect of its client due diligence, the vendor solicitor managed to avoid any liability. But Mishcon was found to be in breach of trust on the grounds that it was an implied term of the retainer with their client that the funds would only be released if the completion was genuine, which couldn't be the case on a fraudulent sale. And the decision put the risk in these kind of cases firmly on the purchaser as opposed to the vendor solicitor, even though it's their obligation to ascertain the identity of their client. And the judge made it really clear in his decision that Mishcon should be held accountable because it had insurance that could cover the full loss suffered by its client and was far better able to meet or absorb it than Dreamvar. He didn't exercise the discretion that was open to him under Section 61 of the Trustee Act 1925, which can be relied upon in defence of the trust if the trustee has acted honestly and reasonably and ought fairly to be excused for the breach of trust. The Court of Appeal upheld the finding against Mishcon, clarifying that even though Mishcon acted honestly in exercising its discretion under Section 61, the court is entitled to compare the effect of the breach of trust on both parties. And Mishcon was far better placed to cover that liability as it had professional indemnity insurance of at least £3 million. The court, however, overturned the findings in relation to the fraudulent vendor solicitor and held that a vendor solicitor does warrant that they act on behalf of the genuine owner of the property. It also confirmed that in relation to the code for completion by post, the vendor solicitor only has authority to release the purchase monies to the true owner. Releasing funds to a fraudster will amount to a breach of trust. By virtue of the same code, the vendor solicitor undertake to the purchaser solicitor that they will only release purchase monies to the true owner of the property, and they'll be in breach of this undertaking if they release them to any other party. In this next case study, we identify key methodologies used by fraudsters to impersonate individuals in positions of authority and to influence people to transfer funds and information to fraudulent accounts. So our first example is a phishing scam, in which a large law firm's HR department received an email from a senior executive asking for staff payroll information. It responded with the details that the executive asked for, which included names and financial information. A short time later, some of the employees from the firm began reporting that they'd been victims of identity fraud. The firm then looked into this and found that a large proportion of their staff had been targeted. And when they investigated what had happened, the firm learned about the email to the HR department, and this hadn't been from the executive name, but had in fact been a CEO fraud phishing scam. The second example that we show, the law firm receives a call purporting to be their bank relationship manager, asking them to move funds to a different account due to an operational problem with the bank. The fraudster had told the managing partner that he'd called him directly because he was wary of the fact that the contact he'd had in the accounts department wouldn't be authorised to make the payment. The managing partner decided to transfer the money, and it was only when the managing partner discussed this with a fellow partner later in the day that suspicion was raised. At that point, the firm contacted the bank and soon realised that they'd been victims of fraud. £200,000 was lost, and no funds were ever recovered. So I think there's a real danger of being quite blasé about the risks and thinking it won't happen to us. As we've identified in the case studies, both large and small firms are being targeted and are falling foul of increasingly sophisticated fraudsters. So if fraud is the outcome, how can we reasonably fulfill our obligations when it comes to identifying clients? And here there's a clear distinction made when it comes to client identification and client verification. So client identification is simply just being told or coming to know a client or beneficial owner's identifying details such as their name and address. Client verification is around obtaining some evidence which supports this claim of identity. And it's here where the profession needs to be particularly vigilant to fraudulent activity. Collecting passport or driving licenses or utility bills just isn't enough. You need to consider what it is these documents are telling you. So have a think, are they painting a picture of a legitimate citizen, or are there in fact holes in the information which might make you suspicious? Why has the individual come to you, especially if you're not based near to the property being transacted? If the vendor lives at a second address, is there a reasonable explanation for this? Is your client reluctant to meet? Or is the source of funds checks revealing an anomaly of any kind? And it's really critical that you factor these sorts of questions into your thinking. Your initial risk assessment, which we'll come on to in a second, will help you to make a decision on what level of detail you need from your client. Be aware of fraudsters. A quick Google search for fake documents brings you to a whole heap of sites that advertise the availability of fake documents, mimicking legitimate documents. And this is just one example of many. You can see this site offering to provide you with fake statements for a fairly insignificant sum of money. Similarly, there are fake passports and driving licenses for sale. So, as well as cases like DreamVar, in which a legitimate identity is stolen and recreated for someone else, are there holes in the story? Do the addresses match? Can the vendor provide information about the property that only they would know? This is part of the risk-based approach that you must be taking to your anti-money laundering procedures. So going back to the statistics provided by the CLC, we can see that firms aren't properly implementing risk assessments on their clients and transactions. Under Regulation 18(1), an independent legal professional's practice is required to carry out and maintain a document practice-wide risk assessment to identify and assess the risk of money laundering and terrorist financing to which the business is subject. These assessments should be completed at the outset of the transaction and should inform you as a business the steps you should be taking to complete your know your customer obligations. And as such, as identified by the Legal Sector Affinities Group's guidance here, I'm going to quote, your risk assessment should record your practice's risk tolerance so that you're able to demonstrate to your supervisor that your CDD measures are appropriate and proportionate. And this is where firms fall foul of the regulations. The risk assessment, which falls part of the AML risk management processes and procedures, should identify when it's appropriate to complete customer due diligence and how it's completed. If this includes using electronic verification, then you should identify it as such. Your risk assessment should also identify when the individual or transaction presents a greater risk, such as matters where you maybe don't build an established and stable relationship with your client, conveyancing being a really, really good example. The legal sector affinity group also identifies individuals who work in high risk sectors, such as public work contracts, construction, real estate and property development, the oil and gas industry, the nuclear industry, mining, including diamond mining and trading, arms manufacturing, supply, and the defence industry. Politically exposed persons, clients you don't meet, and or clients with a high cash turnover business. In these cases, your risk assessments and firm's policies and procedures should outline how you'd undertake enhanced due diligence and how this goes above and beyond the standard checks. So there are no hard and fast rules when it comes to anti-money laundering. The regulations are very outcomes focused, and ultimately you're trying to prevent illegally obtained funds from being legitimised through your business. In its guidance, the Legal Sector Affinity Group acknowledges that no matter how thorough your risk assessment or how appropriate your controls, some criminals may still succeed in exploiting your practice for criminal purposes. Nevertheless, a comprehensive practice-wide risk assessment combined with appropriate risk-based judgments on individual clients and retainers will enable you to justify your decisions and actions to law enforcement agencies, the courts, and your supervisory authority. The critical element, I think, is to document and evidence both processes and the actual undertakings in your money laundering policies and procedures. So what else can you do to protect your business from the challenges of ID fraud and client verification? Like any process, the application is only as good as its implementation. So it's critical that staff understand the risks and take a proactive approach to the risks across the firm. And the greatest risk to your business probably is your staff. Alongside the checks you complete on your clients, your firm should be awake to the risks posed by greater criminal sophistication. So you can see this in the case studies that we've looked at earlier, where fraudsters have defrauded organisations by cloning emails, imitating influential individuals, using a mix of social engineering and technical capabilities to benefit financially. It's really important to embed this awareness and risk culture into your whole organisation and into your governance. And remember, the money laundering regulations are almost unique in that they mandate staff training. So in addition to your money laundering reporting officer, who else has taken an active interest in the risks? Are you looking at technology that can maybe help to support you with this challenge? Do you have security champions? So that's something that I rely on really heavily in our organisation is we have a team of security champions, and that they represent each department. There's no senior managers involved. It's a mixture of people in different roles at different levels, and they act to be the point of contact in their department for security. And they also act as a way of raising issues to the security teams and maybe highlighting things that we hadn't previously thought of. Do you have risk, fraud, and cybercrime as a regular standing agenda item at management and board meetings? And do you lead this from the top? You can sign up to publications like our sister publication, Today's Legal Cyber Risk, to get to know about some of the key issues yourself. Also, the National Cybersecurity Centre's website gives loads of really good and impartial advice for how you can manage some of these risks. And lastly, have you got accreditations and certifications which help to embed this into your culture and governance, and actually verify that doing these steps that you're taking are working. So it's important that it's incumbent upon staff to make sure they do what they can to protect the business. It's really important that this kind of thing isn't just seen as a technical issue. So staff should know that they shouldn't discuss confidential matters openly on public transport. And there's a really nice article about that on today's legal cyber risk, where we tell a real story of something that we observed on a train journey. Not connecting work devices to open networks or Wi-Fi hotspots, which can easily be cloned and hacked. Not clicking on any suspicious emails or attachments, and reporting those to the IT team instead, and actually having an open culture where if somebody does accidentally click on a suspicious link, that they know that they can report that, and it will be dealt with. So alongside the cultural competencies, firms obviously also need to look to implement some technical solutions. So these will involve your IT manager or your IT teams, or maybe even your outsourced IT providers, to ensure that you've got the relevant essentials in place, like firewalls, that your network is configured securely, and that you're updating your software and operating systems, making sure that you've got really good anti-malware, and you've got protocols for passwords and to protect you against email cloning or email spoofing. These kind of basics are a really important part of cybersecurity and account for roughly 60% of all cyber failures. So hopefully you've found this webinar useful. And just to wrap it up, it'll come as no surprise that Lawyer Checker can help you further with some of these challenges. So we do provide a range of options to help you protect your law firm from the risks of ID fraud, client verification, and associated cybercrime and fraud. So I think most of you will be familiar with our account and entity screen, which verifies bank details of the law firm on the other side of the transaction. And we've also released a couple of newer products that you may not yet be aware of. We're delighted to have recently partnered up with Third Fort, an electronic ID, client verification and source of funds checking tool, which uses facial recognition technology, document verification, and a bank linking into a mobile phone app. So when it's ordered, the law firm's client receives a link to download the app to provide all of the information needed to complete client due diligence. This saves you the need for chasing for documentation and reduces the time it takes to onboard new clients. And this is available right now on the Lawyer Checker portal that you log into. We also have our consumer bank account checker that helps to verify the destination of funds when it comes to remitting funds to customers' bank accounts. For example, when you're remitting property funds or divorce settlements, probate awards, etc. When it comes to taking a stand against cybercrime and fraud, we're also helping law firms move along their cybersecurity journey with a number of options, including a tool that stops a criminal from being able to spoof your email address. It's actually quicker and simpler now for a criminal to use your exact email address to send from, rather than going to the trouble of buying a similar email address, configuring it, setting it up, and using that. We also have a range of accreditations that we can offer your law firm. So Lawyer Checker are able to issue Cyber Essentials certificates and Cyber Essentials Plus certificates to your firm. So for any more information about our new ID, client verification and sorts of funds check from Third Fort, or to talk to us about moving along your cyber journey, please contact us. I'll show some contact details on the in the next couple of slides that I'll leave up just for a few minutes at the end of the presentation. So just to finish off, I want to really encourage you to consider what the repercussions of fraud or cyber failure is in your business could be. And as lawyers, we're trained to look at the worst case scenario, and unfortunately, the worst case is pretty nightmarish. We strongly recommend, as do the National Cybersecurity Centre, the government-backed Cyber Essentials scheme. It's a reasonably inexpensive self-assessment which allows you to take a view of your cybersecurity across your organisation, and you can actually gain a certification and a badge that you can use on your website and your email footers to show that you've implemented these basics of cybersecurity. So it introduces some of the technical and cultural accountabilities that we've discussed today. Lawyer Checker is a Cyber Essentials assessor. As a business that revolves around the law, we know how your businesses are likely to work, and we know the nuances of law firms and that they're not the same as any other business. So if you are interested in starting your cyber journey with us, then please contact me and we can discuss more of the options. So thank you very much for your time today. I really hope it's been informative and has given you something to take away. I'm going to leave this slide up for a couple of minutes, and this has contact details for our relevant key relationship managers. So we have Tom Lees in the north, Cheryl in the Midlands, and Emma in the south. So please do take down their contact details and give them a shout for any more information on any of the products or issues that we've discussed today. So thank you once again.